In the case of Moon and Whitehead, two employees attended a conference in Sydney. They were government employees from Canberra, and they both stayed in a share apartment with two separate bedrooms. Essentially, both went out drinking and then visited some sex shops in the city before returning to their apartment. There'd been a prior relationship between the pair. Miss Whitehead claimed trespass to the person for Mr. Moon sexually assaulting her in the apartment. And this is quite an unusual case, I guess, in the employment sphere, although it does involve two co-workers. Mr. Moon was Miss Whitehead's supervisor, and essentially damages of $658,000 ended up being awarded to her, along with originally a $10,000 aggravated damages component. But quite strange circumstances, which obviously took place outside of the workplace, but still in a work context.
I think it's, a reflection on some of the low damages awards in relation to sexual harassment. Yes. That the legal representatives for Miss Whitehead decided to go this trespass to the person route rather than sexual harassment.
Yes.
And, is something that is perhaps something that should be looked at in relation to the problems with sexual harassment laws and the way they're applied.
She claimed obviously past economic loss for not working for a period of months, future economic loss because she couldn't go back and work at the same government department. She also claimed general damages of $100,000, and she claimed a component for treatment. She tried to commit suicide not long after the assault. So the first instance judge in the ACT Supreme Court did go through in a lot of detail the different components, which is something obviously in employment law cases traditionally you're a lot more limited. The aggravated damages component was overturned by the Court of Appeal. They didn't go into much depth as to why, but it was quite a nominal amount of $10,000.
Well, legally, one of the differences that is certainly in Miss Whitehead's favour in the matter is the finding of the court that in relation to trespass of the person that consent is not proven objectively based on a reasonable person, but establishing the actual state of mind of Miss Whitehead. When you're looking at the sexual harassment laws, it's more around what a reasonable person in the position of Mr. Moon would have thought.
Well, that's the situation where they visited sex shops together. There had been some prior flirtations, and I think if they'd gone down the route of sexual harassment, there would have been a strong risk that it wouldn't have been found in Miss Whitehead's favour because of those close proximity of circumstances.
Where even though there's no question on the evidence that there was no consent, whether Mr. Moon could have established that a reasonable person in his position might have thought there was consent.
Yeah.
And that's where it turned as well. Mr. Whitehead claimed that Miss Moon hadn't specifically said no, and her conduct inferred that she was consenting. So that's where the reasonable person came, that he couldn't assume that consent was inferred just because of their prior conduct or because she wasn't saying no.
Yeah.